Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. So go ahead as soon as you join me, put your questions in the comments because I'm here especially for you. Thanks for joining. I'm already seeing my friends joining, so thank you so much. Put your questions in the comments, and I'm just making up for not making the live earlier today. Put your questions in the comments so we can talk. I had a question. I had a question that I wanted to answer today, and it's hi there, can an employer get you deported? So, what I need you to know and understand for your own interest and for your own protection is, even if you don't currently have legal status, even if you are here on a temporary visa, you have rights. You have rights, period. Right? So, no employer can use your immigration status against you to get you to comply with what they want you to do. And if they are trying to force you to do something or trying to keep you under their thumb, they're trying to keep you working for them, they're using the threat of deportation. They're saying, well, I'm the one, and sometimes they're not going to be direct. Sometimes they're going to say things like, well, I'm the one that's in charge of you. I'm the one that's taking care of you. Your employer. So it's either you stay with me or you go home, and I can send you home. I can buy your ticket and send you home. Whenever you experience things like this, it is a big indication that this is a form of labor trafficking. What they're trying to do is use what coercive tactics. So they're making a statement, a threatening statement towards you to make you comply with them. If you've experienced this, there is relief. Now, can an employer get you deported? Employers can, they can certainly adopt tactics to get you deported. Can they physically do that themselves? No. Can they just go straight to ICE and say, come pick up this person and get them deported? It's highly unlikely. But this is where I also want you to think about yourself and think about your best interest in the future. If someone like this is threatening to send you back home or force you to go back home or to get you deported, you have options and you need to take advantage of these options by going and seeing if you do qualify for relief, immigration relief on your own through the T status, right? Where you are able to get a 4-year work permit, you're able to get your updated status here, your updated I-94, and even a path to permanent residence. And it also is there for you to be able to seek the protections you deserve, to be able to put the immigration on notice that you are the victim of trafficking. This is one of the main reasons that it is here for you. It's despite the fact that you are here working without a permission, despite the fact that you may have crossed the border without permission, despite the fact that you may have overstayed your visa. If you're the victim here, you are the one being threatened by an employer, it means that the T status is there despite all of this to provide you with the protections you need. And so it means that it prevents you from getting deported. So even if in the long shot, an employer goes above and beyond to go ahead and report you or sabotage you so that you do get into immigration problems, if you take the steps to protect yourself, you beat them to this, then you'll be recognized as the victim here, and the employer is going to be outed as the perpetrator, the trafficker. So I don't want you to feel, while I can never say don't, because I can't never be in your shoes. I know this is nerve-wracking. I know that you fear, especially immigration and ICE and all of the consequences that comes with applying for an immigration benefit or going to immigration. But this is what this is for. This is here because you need protection. And I help my clients to get through this process successfully. I advocate for my clients and I do a detailed evaluation first to make sure that you do qualify for this before moving forward. So, one thing I do want to say is also look at the position you're in now. So sometimes people fear going and applying for immigration benefits because they're afraid that somehow it might backfire and they may end up being the ones that get deported or get into problems. No, it's once you qualify for this, it's highly unlikely that that is going to happen to you. But when you look at yourself in this position now, are you at greater risk living in the shadows, looking over your shoulders, where you have nothing on the record saying that you deserve this protection? At any day, if at any point, if the law changes, if there isn't somehow an immigration crackdown, if an employer does decide to go ahead and find a way to report you or to accuse you of something so that you do get into trouble and you have nothing on the record to show that are the victim or you deserve relief, then you are at a greater risk in that position because it means that you have nothing to show or to justify you being here. And oftentimes, if it ever does get to the point where you are you detained by ICE or you find yourself in a deeper type of immigration situation, oftentimes, if you don't have anything on the record to show that you deserve this relief, it means that you're going to end up being removed, or it's going to get a lot more stressful and a lot more complicated. So it's best to make sure that if you qualify for this, you take action to protect yourself because nobody else is going to do that for you. And it is so satisfying for me personally and professionally to be able to help people who think they have no options, who think that they have to be subjected to this kind of mistreatment, these kinds of threats, these kind of abuses by an individual. It gives me such satisfaction to see them be able to rise up out of that and not have any fear, and in some case they in their own way stand up to the threats that they're facing, the employer that is giving as the threatening them in this way. They're able to then empower themselves and rise up against that. So keep that in mind, right? Keep that in mind that an employee, you have rights here, and this is why we do have the T status here to provide you the protections you need. Um, and an employer, they just because you're at one thing with my clients that I hear time and time again is an employer who will say things like, "You don't have your status. Who are they going to believe, me or you? You're not supposed to be paid a lot of money because you're not even working legally. You have to work 24/7. How are you going to say no? You have to do what I say because they know you have nowhere else to go." And so I want you to know that the employment laws in this country do protect the employees despite their immigration status. So that, for example, in regards to the Department of Labor, whenever they're looking at violations, they're not looking at your immigration status. They're looking at the employer's violations. They're not in cahoots with immigration. They're not reporting any of the they're not reporting any of the employees' immigration status to immigration. It's completely separate. What they're looking at is did the employer violate your right to right in this country? Did they violate the laws, the employment laws? And if the answer is yes, then they only focus on that part of it. For example, the Department of Labor, they don't say, well, yes, if this was a citizen or resident, or if this person had their visa current, then they have all the protections, and we would find this employer liable. But this is not a person with their papers, so we're not going to find the employer liable. That is not the case, right? Despite your immigration status, they will look at how you were treated, whether there were violations, and then they will act accordingly. So this is all there to tell you that you should not be thinking that you have to put up with violations against your right. You don't have to be subjected to abuse or mistreatment by anyone, by especially by an employer, because they have no right to do that to you. Now, once you apply for this benefit, it's called the T status. If you have been threatened by an employer, if that employer has said that they're going to get you deported, if they have said that if you leave, they're going to call immigration, if they have said they're going to send you home if you don't comply with what they say. For example, if you're asking for more pay, if you're asking to work less, and they're telling you that they're going to send you back home because now you're asking too many questions, that's coercive. And when we're dealing with coercion, it also means that the coercion is used to keep you compliant. That's a form of labor trafficking. And it means that you can get this relief. Now, not only is the relief available for you, they have the relief is available to your spouse, to your children, and also if you're under 21, to your parents and to your sibling who is under 18 and unmarried. So it goes a long way to help a lot of people, and that's what I find fulfilling with the work that I do. All right, so I'm going to answer some questions. So let's go to the comments. Bear with me as I go through the comments and answer these questions. So, does the employer get prosecuted in any way? I'm asking just in case of retaliation to the abused. So, this is up to the Department of Labor. So, when I represent my clients, I deal with all sorts of varying types and forms of trafficking. And so, if the Department of Labor, they do their own inquiry and they determine, and even some other law, because it could be not only labor related, it may be some other type of physical, verbal abuse, threats that may even involve other agencies. And it really is completely up to the agency to determine whether they would move forward with that process. But that is not what's required. Prosecution is not required to get the T status. So you don't necessarily have to be involved in a prosecution or involved in an outright investigation by a law enforcement agency like the Department of Labor to be able to get the T status. Now, another thing is with retaliation. And this is why the T status is a good option, because the T status is completely confidential. That means that they are so protective of your process that they will not even publish the status updates online, right? That is how confidential the process is. And in addition to this, depending on the nature of if, for example, if the Department of Labor is involved in a situation where the employer has committed violations of employment law against you, um, they also keep it confidential within the Department of Labor. So usually, even as the attorney, if I am working with the Department of Labor and I'm working with immigration on the matter, so I'm filing the immigration petition, but I'm also working with the Department of Labor in cases where we do make a report. What I want you to know is that the Department of Labor usually corresponds with me as the middle person, and they provide me the documentation if necessary. So if they do say, we want to submit that extra documentation to support the my client's application for the T status, they provide me the documentation and then I provide it to the immigration. So that's another thing. But the upside of this type of application is that we're not even required to have this documentation signed by the Department of Labor or any law enforcement agency. All right. If I have an SSN through J1, do I still need to file Form I-765? So, yes, absolutely. Because even though you do have an SSN, if your J1 is no longer valid, then you are not able to legally work without the work permit. The I-765 is the work permit application. So if you don't have that work permit, even if you have an SSN, you're not able to work. So if you go and apply for a job and I do know that employers hire people who don't have their papers. But if this is a type of employer that requires that you have the work permit, then that SSN is not going to be the only thing they require. They're going to require you to have that work permit as well. If your husband has a felony on his record and you can't add him on a list, but we stay together, how do we prove to the immigration that we stay together? So, this is where I say one size does not fit all. And it comes down to brainstorming with my clients. If we have a situation where they can't go on the lease together, then it's brainstorming about other types of evidence to use to show that you do live together. For example, do you have friends and family who are aware that you live together? Can you have even though you can't be on the lease, is there a landlord or a person in the office who can attest to the fact that the spouse is currently staying in the apartment? I don't know if that would even be, it just depends because if they have a felony and they're doing a background check, chances are the office doesn't know, I know, but it just depends on the landlord tenant relationship and the reason that he can't be added to the lease. If the landlord understands why they can't be added to the lease, but they're willing to write a statement or an affidavit attesting, confirming that the spouse is living there, that's another way. Common mail. So if you have mail with the same address, if you have a bank account with the address and both of your names on it, use the bank statement. And we'd have to what I do when I represent my clients, I learn about the type of marriage that you have. What kind of arrangement do you have? Because not every spouse is going to do things the same way. So I talk with my clients to figure out how do they exchange money, how are they sharing in the bills, what assets do they have, what do they pay for together, and then we come up with what the best evidence is. What if you come through the border? So if you came through the border, now if we're talking about the T status, you came through the border. then you will be required to submit a waiver. The waiver is pretty standard for my clients who have crossed the border without permission, and it's a relatively generous waiver where if we do prove that there is a form of trafficking or was a form of trafficking that did take place, they're usually willing to approve that waiver for crossing without permission, crossing the border. Now, if you're asking about your options after crossing the border, did you cross the border with inspection or did you cross the border without inspection? Were you paroled into the country, meaning that they gave you a special permission saying, yes, you can come into the country? Or were you given a notice to appear in immigration court? In those, it's your options are going to depend on those, the nature of your entry. How was it done? How were you processed into the country? And then who are your relatives? How do you qualify for relief? Do you qualify for TPS, that's temporary protected status? Do you qualify for asylum? Do you qualify through a family member for any kind of, do you qualify as a victim of trafficking? These would be things that we'd have to talk about in an appointment. Now, you can go ahead and schedule the appointment. If you go to the link in the profile, you can schedule your own appointment. And on YouTube, on Facebook, and Twitch, if you go to the description of the video, you'll see the link to schedule your own appointment. You'll also see the link to the website where you'll be able to get in touch with us at the phone number. You can submit the contact form. And right now, it's after hours, so the online chat wouldn't be open, but it's open during the office hours of 8 to 5. All right, so do I request a new Social Security card or the I-485 if I got one from the J1 program? So it sounds like you're asking me very specific questions on your forms. And what I do want to let you know is that you cannot depend on any information that I'm giving you individually, right? I cannot be giving you individual legal advice, especially in regards to what you should or should not be putting on your forms. Generally, it's never a bad idea, and this is general information, it's not legal advice. But it's not a bad idea to ask for a new social security number when you're applying for your work permit again. However, always make sure that you get individual legal advice because the information I'm giving you here is not personalized legal advice, it's general information. So my VAWA case will be 1 year next month. I have received prima facie, which will expire in December, and I have also received my work authorization and advance parole. What is the next expiration? So the work permit is usually 2 years. And it's clearly on your work permit application. So your prima facie, when it expires, you'll automatically be issued another prima facie if they don't make a decision by then, which right now they're making a decision at around the 2 year, 2.5 year mark after the filing. So it is taking a while. Some of them are even taking 3 years. So, the next step is going to be that decision on VAWA. You may get a couple of automatically renewed prima facie determination letters. And you just have to remember, if you haven't gotten your green card by then, remember to renew your the work authorization and your travel document. You should do that around 6 months before it expires to give yourself enough time to get the card. But they're also issuing, once you apply to renew the work permit, they are issuing extension letters that allows you to keep working while they process and produce your work permit card. Can I change my divorce name to my maiden name? as I want to renew my passport since my case is still pending. So yes, you can go ahead and take those steps to change your name back. It should not affect your process. If you do have an attorney, make sure you talk to your attorney about just providing the changes, the information about your change of name, and so forth. But if you're divorced and you don't want to keep the name anymore, you can always change it back, and it shouldn't affect your process. Hi there, Raul. Nice to see you. All right. I'm scrolling through. Hang tight while I go through your welcome, Mellow, while I go through your questions. Um, So I overstayed my visa. My dad is an American citizen but retired. Can he file for my green card? So if you are over 21 or over, he can file the petition for you. But as for staying here and getting it, it's not going to be possible if you're 21 or over. If you're under 21, then yes, your dad can file for you, and you can file for adjustment of status. Just do it quickly before you get to 21. Now, if you're 21 or over, your dad can file an I-130 petition, but it's not going to allow you to get your green card while staying in the US through the adjustment of status process. That is only if you have a current status, you have, which would be your visa, but here you said you overstayed, so you, that alone is going to stop you from getting the green card while staying here. The other thing is that you have to show that your priority date is current, which for the category you're in is not current. And it won't be current for another 6 to 7 years. So you have quite a wait even after the petition is filed to for them to process your green card. The other problem though is that they're going to process your green card at the embassy. Unless they change the law before then, they're going to process your application at the embassy in your home country, and you're going to be stuck here. If you leave the country to try to go to that interview 6 or 7 years from now, you're going to get a nasty surprise, because you're going to get there and they're going to tell you you're barred for 10 years. And good luck after the 10 years of getting any, or in between and in that time of getting a visa. Maybe after the 10 years, 10 more years, you could get your green card. But once you overstay over a year, you are barred for 10 years if you leave the country. Now, the solution to this problem is that they do allow, at the point your priority date becomes current, they do allow you to apply for a special waiver that forgives the overstay and allows you to go to the interview at the embassy. So it's called the I-601A waiver, but that waiver is going to be based on you showing that your parent will experience extreme hardship if you don't get the green card. So you have quite a few steps ahead of you to get to the solution here. So in a nutshell, it's not a quick and easy solution through your citizen dad if you are 21 or over. However, let me just one more thing. I just want to note here is that if you do fall under Section 245I, then that could be a way that you stay here. So under Section 245I, if you had a previous petition, doesn't have to be your dad, could have been anybody. If on or before April 30th, 2001, a petition was filed on you, a petition that would have been approved, it's just that maybe something happened and it just never went through, then you could apply. You could, it's like, I like to refer to it as a type of amnesty, where you could stay here as long as you can show that that petition was filed for you before that date. Then you could apply for adjustment of status under what's called under INA Section 245I. That's a provision in the law that makes an exception for individuals who were filed for before 2001, so April 30th, 2001, but it just didn't go through. And in some cases, you have to be you have to also show you are physically present in the US. So this is where it's so important to get a consultation, because if you do fall under Section 245I, it could be the solution here. All right, so go ahead if you want to evaluate your options to stay here and get permanent residence. This is where it's so important to schedule an appointment so we can talk about your circumstances, talk about your background. This is why in my consultations, I ask very detailed questions about my client's background, because I want to understand all the different ways that they can qualify for relief under immigration law. And you'd be surprised at how the things you've been through can actually get you relief here. Good afternoon. I do not have your work permit and I would like to go to work. So, now, if you don't have a work permit, it's very unlikely an employer is going to hire you. You do have employers that do hire you under the table, but you have to know how to navigate doing that. Generally, employers are required to ask for some form of work visa, permanent residence, or employment authorization, the work permit, for you to be able to work legally here and get a job. I'm on an H-2B visa. Can my mom file for me while I stay in the US? Or which other way can I adjust status? Generally, yes, but you when you say your mom can file for you while you're here on the H-2B, the H-2B visa is a seasonal visa. So it's usually what I see is it gets renewed every 6 months. Employers are in the practice of doing that. Or you may have to change over to another employer after 6 months of working for one employer. And you really have a maximum of 3 years to work on that H-2B visa, to continue to be here. Now, if you are 21 or over, it's taking anywhere from 5 to 7 years for the process to be completed. And you would have to maintain your H-2B visa for the duration of that time to be able to qualify for adjustment of status eventually. And then also keep in mind that with a petition pending, it may also interfere with your eligibility for the H-2B, because now with the I-130, you're in the US, you have a pending I-130, and you're on the H-2B. They could see that now you have immigrant intent and not a temporary intent to be here anymore, that you do have some permanent intent. So it can also affect your ability to keep that H-2B visa. So you'd have to be careful about the timing on that as well. So do you do EB3 visas as well? Yes, absolutely. You can give the office a call, and we do. Now, when you're doing an EB3 visa, this is the green card, the employment-based green card. We do have to represent the employer. So if you're the employer, definitely give us a call and we can talk through whether you qualify. We'll talk through the process with you and get started. Can you travel when the T visa has been approved? So great question. No. Now, keep in mind, I'll say T visa. Sometimes you'll hear me say T status, but there's a difference between the T status and the T visa. The T visa is granted at the embassy outside of the US. So some people may apply from outside of the US because they have been the victims of trafficking and they want to come to the US for relief, or they may need to come here for a purpose. However, when you're here in the US, you don't have status, and then you apply to get relief through the T status, It means that you're here on a legal status. You have current status. But usually what happens is when you're granted a status, once you leave the country, you lose that status and you have to go back to the embassy and reapply. The why this is not worth the risk of traveling is because if you go leave the country on T status, say you even go back to your home country, you're going to have to go back to the embassy and apply for the T visa to come back in. And when you do that, what's going to happen is they're going to then evaluate you from scratch. They're going to evaluate that application from scratch. And so, for one, if they're evaluating your application and they see you're supposed to show that if you go back to your home country, you're going to experience extreme hardship. Well, how is it you took a trip to your own country that you said you'd have extreme hardships in, and now you're here applying for a visa? So it's just not worth it to travel. However, the T visa does lead to more permanent options like the green card. And once you do have permanent residence and you get citizenship, then you do have the option to travel without any consequences there. Does it does I think this is does a fee apply to the I-131? Got a denial a week ago if I want to reapply with I-485 pending. So it depends. When you're applying for the I-131 concurrently with the other applications as the spouse of a citizen, then the fee is covered by, so the fees waived for the I-765 and the I-131. So in this case, it depends on what type of adjustment of status you're applying for. If you're applying for a different type of adjustment of status, then the I-131 fee may be applicable. But this is where it's important to also make sure, because there are different types of adjustment of status applications. So you have to make sure you're reviewing at least the instructions to see where the fee applies. Great question here. Can your employer file for you if you are undocumented? And now why this question? So I'm going to tell you one straight up answer. No, right? That is the rule. No, unless there's just one exception, and that file for you is not going to mean that you're going to stay here. If you apply for a waiver and the waiver, as in the I-601A waiver, based on your relationship with a citizen or resident spouse or a parent, then you could get the petition by the employer approved, but you still have to go back to the embassy in your country to finish the process. So my answer here is, if you're out of status, you don't have any status here, and an employer is telling you they're trying to lure you to start working for them, telling you they're gonna pay you and they're gonna sponsor you, or sometimes the employer, they really have good intentions, but they just don't know themselves, so they're telling you they're gonna sponsor you. The answer is no. That's the rule and not the exception here. T visa and asylum, which one is best? T visa. Well, the asylum is taking very long right now and is frustrating, right? So, if you apply for asylum, you're looking at a possible 2 years to even 5 years of being in limbo for that time. So and the thing is, though, the asylum and the T, they can be completely different. um, I do have clients that qualify for both, and you can apply for both, by the way. But if you do have to pick between one, the fastest way to get status here would be the T status, and then it would allow you to move on to more permanent options like the permanent residence. And once you get permanent residence, you have a path to citizenship. After T visa approved, if apply for the green card, how many years will you get? 10 or 2. So 10-year. It's going to be a 10-year. Good afternoon. If I came through the border and went through inspection, can I get married and adjust my status and get a green card? Now, that is a more complex question because even though you came through the border, what they may have given you is a notice to appear, and that's not considered parole. If they did provide you a very specific type of parole, not conditional parole, then that may be a possibility. So it depends on the type of parole that you enter the country with. How long does filing take for an adult over 21 years old? So 5 to 7 years. You're waiting to remove the condition from your green card. In the process, you get divorced. What should you do? Read the USCIS. Just wait on the card, or you have to notify the USCIS. Don't make this mistake of just sitting down and hoping that luck is on your side, because guess what's going to happen? You sit down, you don't tell immigration that you got divorced, you wait for that green card to come in the mail. Great, you got your tenure. Now it's time to apply for citizenship. And you go ahead, you apply for citizenship. Now you do have to disclose on your application that you are divorced, and you have to put the date of the divorce. You have to provide the divorce decree. And what that officer is going to see is the officer is going to see that the date of your divorce was before the date of your green card. And what they're going to do is say that you misrepresented facts. You did not inform them that you had this divorce. You applied as if you were still married, and that's misrepresentation. And what that's going to mean is that they're going to go back and say you're not even entitled to have that green card. So you could be looking at a referral to immigration court for removal proceedings, rather than a citizenship. So you may have luck on your side at first, but then when it's time to apply for citizenship, that's where it's really going to catch up to you. So you have to make sure that when you have changes like this, you take the steps. Now, what you do have to do is you have to apply for a waiver. You have to submit a formal waiver that's going to allow you to apply on your own. You must do that. And this is what I help my clients with. Also, you can give me a call and we can get started on providing them a waiver so that they change it from a joint process to your own process, so they process it properly and you don't have any complications in your citizenship, for example, in the future. What's the minimum period of waiting for asylum case interview? So there's not necessarily a minimum. So I wouldn't say there's a minimum. I mean, if you're asking what's the shortest period of time, so I've seen a year after applying to get the asylum, but that's really an exception to the general timeline than what's happening now. All right, so that's it for me. Thanks so much for your time. I will be back tomorrow. I'm hoping to make it at lunchtime tomorrow where I can answer more questions. So look for me at between 12 and 1 where we can talk about your questions, and I'll come with a topic as well. Thanks so much for joining me. Have a great day. Bye-bye.